information. The victims have to listen and absorb these with zero prior knowledge, only notifications of the offender's weekend passes and their minor program participation records. The strict criteria limits victims to write about emotional, financial pain and keep it short. Why the strict rules for victims but not for the offender? There must be a better way to balance victim input and obtain meaningful conclusions simply by broadening the consideration of the victim's perspective. Secondly, there are very strict, rigid rules pertaining to parole hearings. We are told we are just observers, as if we don't have a considerable stake in this. The offender's family members sit directly behind the offender, all facing the parole board members. The victim's family is then escorted in and sits at least 5 rows back behind the offender's family and friends. You have to strain for hours to hear. This is especially difficult for seniors. It's demoralizing, tense, and exhausting. You are then given the opportunity to read your statement to the back of their head. I'm told this rule is in place to protect the victims, but just as I've also been told by many prosecutors, no two crimes are alike. Same outcome, but different circumstances. Well, I would like to say that no two victims are alike. Many would like to face the offender, observe their facial expressions, their body language, possibly look for a glimpse of remorse. This rigid rule should be changed to fit the victim. Victims should have the choice. As it stands, the process is far too comfortable for criminals, while the victims are at the mercy of the rules. And in the same vein, a parole hearing should not allow the criminal to fill the room with relatives, friends, and neighbors and have dozens of statements in support. The large presence of those who support the offender is intimidating to the victims and also gives a very false impression to the parole board. It's not relevant to the crime committed. The whole parole hearing arrangement reduces the status of the victims in comparison to that of the offender. In addition to the challenges of the parole hearing itself, Corrections Canada is extremely difficult to get information from. Prosecutors appear far too busy to care. Parole board members seem like they've already made their decision. For example, the decision in my case was literally identical with many other cases, including the Marco Muzio decision. It's copied and pasted. How can such serious
Ms. Arsenault, sorry to interrupt. You're going to have to wrap up, and we'll try to get some of your answers out in the questioning of it. I apologize, but we're in the interest of time.
Just 2 more sentences.
Sure, go ahead.
How can such serious decisions for such serious crimes be so generic? To me, that's a red flag. In conclusion, it's high time the victims that have been harmed are given consideration, at least equal to that of the offenders. I have many recommendations. Thank you.
Thank you, Ms. Arsenault. Really appreciate it. I know it must be difficult to relive some of the aspects of what you've been through. I'm next going to ask Mr. Irwin Waller, who's in the room, for 5 minutes. Thank you.
Thank you for the invitation to appear before this committee on the government's obligations to victims of crime. It's good to be doing this after finally the federal government has appointed a qualified and energetic federal ombudsman for victims of crime. But this appointment is a long way from enough to meet obligations to victims of crime at standards equivalent to what has existed for some time in other comparable democracies. I've set these out in my book, and I will leave one copy of it. The book is Rights for Victims of Crime, Rebalancing Justice. The book identifies a series of fundamental rights, if you like, obligations for victims of crime, and shows how police can be first in aid, services can help victims to cope and recover, reparation can restore, victims can be heard. Victims can be heard, as you've heard, they're not always well heard in our parole system even. A comprehensive model and budget are put in the book that could be very influential on what I'm going to propose. The book also asserts that prevention of crime before it happens is as important as rights for victims. Indeed, today we have knowledge that we could reduce victimization in Canada, both property and violent crime, by 50% in the next few years. and this would be consistent with Canada's commitment to the UN Sustainable Development Goals. My book on Science and Secrets of Ending Violent Crime sets this out using proven strategies, sometimes from Canada even, and from other democracies. Every year, millions of Canadians are victims of crime, suffering losses, trauma, and a lot more. Cumulatively, these are estimated in tens of billions of tangible and intangible losses. Unfortunately, we continue more of the same, and so do not get different results. We allow violence and property crime because we fund short-term projects in pilot areas instead of sustained and adequate investments in smart prevention where it's most needed. The services and justice after the victimization exist some of the time in some of the provinces for some of the victims, but they're generally not adequate or consistent across Canada to meet enough of the needs. The current groups in the federal bureaucracy and the Bill of Rights are totally inadequate to what is needed. The units in the bureaucracy are too low, rarely have the skills needed, certainly don't have funds or mandate. In some, we need a prevention and victim justice services Canada and not just a corrections service Canada. So I'm going to propose that. I'm recommending that you look at developing legislation and funding federally so that victims of crime in Canada can have effective policies to prevent victimization and provide services and justice after the victimization. These must be consistent across Canada and comparable to what exists in other democracies. So I'm recommending a Crime Prevention and Victim Justice Act. It would establish an Office for Crime Prevention and Victim Justice headed by a Deputy Minister and reporting to the Ministers of Justice and or Public Safety. Clearly, it has to work in collaboration with the provinces, territories, and Indigenous leaders. The federal government must provide this office annually with the equivalent of 10% of what it's currently spending on policing, courts, and corrections. Half of that funding going to prevention and half of that to improving services. The office would develop national standards, which we need, train officials and others, fund research and development, and ensure data collection is focused on results. What gets measured gets done. What gets measured gets done. It would also share costs so the provinces, territories, and Indigenous leaders can expand their own planning and implementation of effective prevention and services reparation and other components of victim justice. The Act would also legislate the role of the Federal Ombudsman, which would be strengthened and would report to Parliament with an annual budget similar to the correctional investigator. So I'm recommending that you go for it and actually make a difference to how victims are protected through prevention and how their basic rights are met through funding and legislation and leadership that comes from the federal government. Thank you.
Thank you. That was in time and on time. So next we'll have Joanne Wemmers from the University of Montreal for 5 minutes.
Thank you. And thank you for the invitation. It's a pleasure to be here today. I'd like to as well congratulate the government for choosing Professor Ben Roebuck as the new ombudsman. It's wonderful to finally have someone in that position, but there is still a lot to do. To begin with, victims of crime Ms.
Wemner, if I can interrupt, I think the interpreter's having a difficult time listening to you. Maybe move the boom a little bit up. Yep. And
is that better?
I don't know. I'm going to see their signal. Say a few words. No?
I can say a few words. Is this better?
I'm just going to ask you to just pause and wait. They're talking to each other, and as soon as I find out, I will convey that.
Thank you,
They're
Mr. Chair. If I may, just to direct you, Madam Wemmers, if it could help, you could select in the bottom of the screen at your left, select a microphone.
Yes.
Yes. Have you selected one?
Yeah, I can. Is this better? Is this better?
Yes, if you can just continue speaking, we'll do the sound check at
Test?
the same time.
Okay, I will continue speaking. Let me know if I have to change it.
Monsieur
It's
le
all fine
Président,
now, thank you.
point d'ordre. Avant qu'on
Before continuing, could you please confirm if all of the sound tests for all of the witnesses were made before the beginning of the meeting? And were they successful? In this case, I didn't do a sound test. I was not available before. I didn't do a sound test.
She was not available at the time, so the other two were tested. Unfortunately, she was not. That was the case, but it's now corrected, so we're on track.
OK, parce qu'on me demande, Monsieur le Président,
Mr. Chair, inaudible microphone, please. We want each witness to be tested beforehand, and unfortunately, most witnesses, even when they speak French, appear in English. It's unfortunate, but that's how things are. And we must ensure that everybody is able to understand the witnesses. I would like to insist on sound tests being done systematically before each meeting. Thank you, Mr. Chair.
Ms. Webner, if you can start from the beginning, if you don't mind.
Okay, thank you so much. So again, I began by congratulating the government on the new nomination of Professor Ben Roebuck as the new ombudsman. It's wonderful to have that position filled. However, there's still much to do for victims. Victims of crime in Canada can still not fully rely on their rights. And addressing this problem starts by better applying victims' rights in practice. We need to strengthen victims' rights, and that means enforceable rights for victims of crime. The Crime Victims' Bill of Rights is a great beginning, but there is no recourse, really, and that needs to change. In the Crime Victims' Bill of Rights, we talk about reparation, restitution orders in particular for victims of crime. I think it's important as well that the burden shift from victims' shoulders, who have to chase after their money from the offender if ever their restitution order is imposed, to the state. Already the state is responsible for gathering fines. Restitution orders are very much like a fine. There is, from a victim's friendly perspective, if we really wish to do something for victims, that would be an easy fix that would make restitution orders a lot more feasible for victims. As I said, shift the burden from them. It's also important, I think, to include other forms of reparation, such as restorative justice, victim-offender dialogue, victim-offender encounters, as they can also offer reparation to victims as well. The current focus is largely on offenders' responsibility for the harm to victim, and it's important to recognize that in addition to that, there is an obligation of the state, which is unfortunately too often ignored. An obligation of the state to victims to promote healing and to provide services. For example, facilitating victims' access to compensation programs. Unfortunately, victims across Canada do not all have access to compensation programs. Even when they are available, they're often limited to victims of violent crime, ignoring the tremendous impact of nonviolent crimes such as cyber victimization, fraud, identity theft on victims. Also, victims of terrorism are not always included. And with that, I include domestic and international terrorism. Victim support, healing is very important. I think this is something that we should together work to facilitate, promote, to reduce vulnerability, and with it, the risk for victimization in the future, and build resilience in our community. The research on multiple victimization, polyvictimization is clear that people can have an increased risk. Certain groups can have an increased risk, become more vulnerable, and it's very important to offer how victim support can actually reduce the risk of victimization in the future, building resilience. There's an issue of victim protection, safety. It's a fundamental need of victims to feel safe, for all of us to feel safe, not only victims of crime. It's required for the healing process to begin. It should be a priority. And unfortunately, victims often are left feeling unsafe What can we do to improve the safety, the protection, better protect victims of crime? And I can point out that elsewhere, for example, in the European Union, they're considering measures to strengthen victims' protection by introducing minimum standards on victims' physical protection throughout the European Union. Important, I think, as well, especially in a country like Canada, to work together for victims' rights, strengthening collaboration and coordination between all relevant actors. This is something that we need to do. We do at our university as well with our project that looks at and gets criminal and law students working together to serve victims, to promote, facilitate communication, collaboration across disciplines, across professions, to provide victim support across the country, promote access to justice for victims, and sharing best practices. I mean, there are things in place, for example, the Victims Justice Network, which exists, but unfortunately they're underfunded. They don't have the funding necessary in order to be the service that they can be. So I think that it's important to promote communication, the sharing of best practices across Canada, and things like the Victims Justice Network, which is a virtual e-based, online-based service, is an important tool which would allow us to do that for stronger collaboration on victims' rights across the country. It would enhance resilience, facilitate communication, and help us to develop a national victims' rights strategy from the bottom up, ensuring a coordinated approach for victims' rights across Canada so that victims across Canada would have access to at least minimum standards meeting the criteria of the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power. I think it's important to recognize that crime, yes, is a wrong against society, but it's also a violation of the human rights of the victim. And giving victims' rights that importance, that status, that recognition that we give to human rights, fundamental rights. For example, the right to dignity, to privacy, to liberty, and to safety.
Thank you,
And
Ms.
with that, thank you. I'll end there.
Thank you, Ms. Webner. Now we'll go to our first round of questions for 6 minutes, and we'll begin with Mr. Cooper.
Thank you very much, Mr. Chair, and I want to thank all of the witnesses for appearing this afternoon. I'm going to direct my questions to Ms. Arsenault. Sherry, I know it's not easy to appear before a parliamentary committee, especially as a mother who lost a son in a horrific crime that was committed, an impaired driving crime that resulted in the murder, as you said, of 3 young men, 2 18 years of age and I think a 21-year-old. And it's tough to be able to put oneself in your shoes. And I know we've had conversations over the years about the challenges of navigating through the justice system, and in particular parole hearings. You've gone to Winnipeg to attend them, and as we undertake this study at the conclusion, we're going to put a report together with recommendations on how to improve supports for victims. So maybe at the outset I will ask very broadly if you have any recommendations that would help victims better navigate the system, specifically as it pertains to parole hearings, or anything more broadly than that.
Thank you. I hope you can hear me. Right off the bat, when the justice system, there are resources out there, but nobody tells you about them. If you don't have someone amongst you that digs deep to find out resources, you don't even know that you have to register for parole hearings. A lot of times, in fact, people don't even know when the next court date is coming up because the prosecutors may not engage. So my recommendation is that there's actually a government entity that takes care of that to make sure every victim, especially of serious crime, is given all the resources and help to navigate through that. Not everybody can fill out forms and paperwork. A lot of times people are in very deep grief. So there needs to be actual help. You cannot not just rely on the prosecutors.
For that, and I know we've discussed in the past the fact that these hearings can be quite intimidating from the standpoint of a victim. So can you speak to that, and perhaps any recommendations that you would have on how these hearings could be made a little easier for victims?
Well, right off the bat, I don't know how to say it any nicer. You are read the Riot Act. You are told if you make a sound, you will be asked to leave immediately. This is at parole hearings. It's you feel like you're almost the criminal. You are told to be quiet, and you are told to read your statement and not deter one word off of it. And then you're to sit down and be quiet. We were afraid to even cough, to be honest. So they're very intimidating. And, after 4 or 5 hours of straining to listen, because they plunk the victims way in the back of the room, many rows from the parole board members and the offender and their people, it's exhausting. It's just absolute exhausting. And then only to go home and 2-3 months later get another letter that they're looking for parole again. And you go through it all over again if you so choose to.
Anything that could be done to address that?
Well,
and also, maybe because my time is limited, you spoke about the fact that the criminal has his or her back turned away from the victim or the families of victims. Can you speak to what it would mean to actually see the face of the man responsible for the murder of your son?
Well, to me, that is a choice that the victims should have, whether they want to face the offender that made them a victim. That should be their choice, because some want to face them. I think the offender should have to look a mother in the eye. I don't understand why the big protection. No two victims are alike. They should have the choice to speak to them, to look in their eyes and read their statement to them, not to the back of their ears. I believe that would greatly, greatly help victims in the healing process too, if they were made to feel like their input actually was going to the offender, not to the back of their heads.
Okay, well, I think my time is up, so thank you very much.
Thank you, Mr. Cooper. We'll next go over to Mr. Naqvi for 6 minutes.
Thank you very much, Chair, and I want to thank all the witnesses today for their presentations. I'm going to start with Professor Waller, if I may. Thank you again for being there. You and I have had many conversations around rights of victims, and you've been quite helpful to me in my previous roles at the provincial level in helping guide and the work that we did in reforming the Police Services Act and looking at things like crime prevention and community safety and well-being planning. I have read not all your books, but at least I think 2 books. So thank you for giving me those copies, and been quite instructive. To me, you started your presentation by talking about how the current Victims' Bill of Rights at the federal level is, I think your word was, inadequate. Can you speak to some of the gaps in your view that exist in the current legislation?
I think the Bill of Rights is frankly a bill of goods. There is no remedy, so you shouldn't ever have used the word right. Joanne Wemmers has detailed some of those, that you have to go through your own civil procedure if restitution, you're not provided with information. I think one of the fundamental problems is that we don't actually know anything about what difference is made. And There was a promise to do a main report evaluating it, but we don't really have data. We have no idea whether people were better informed, whether restitution was ordered more, whether people were better protected, whether they actually had any participation. As most of this stuff is in the provincial domain, we have no idea if the provinces are doing this. You know, the Ombudsman is great, but we need a complete overhaul of what's going on. Let's just start with what was mentioned by the previous witness. Information. When I was a senior official in the Canadian government in the 1970s, the Edmonton Police gave out a card to every victim. And on the back of this card, on the front was a phone number. It was 1979. And the back of this card were the various services. And the chief had an office working for him, so it was up in the bureaucracy where it should be, and if they didn't give out this card, then it was a disciplinary offense. But it gave basic information about things like compensation and services. Fast forward to 2022. Canada does not have a basic role for what the police should do to provide victims with information. We do not have any policy of how the police can refer victims to services that can help them, if by any chance they actually exist. This is so fundamental. And the RCMP are roughly 1 in 3 of all police officers in Canada. It's in the federal mandate for the RCMP Act to be changed to require every RCMP officer responding to a victim to provide this basic information. We live in the IT age. You can give people information, leaflets, and you can give people a link, and you can also follow up. You can share the information. Canada is basically backward. And we need to move into the world where victims matter. And we need legislation federally that will make a difference. 1984, Senator Biden, a young senator, was one of the senators that approved the Victims of Crime Act. This was basically a way of providing funding to states in the U.S. so that they could have compensation, so that they can have services, so that they can have specialized services, so that there was an annual conference, so that there was better data, all of those things. 1984, they were doing that. We, at one time, gave funding to help provinces put compensation in place, but that was abandoned. But we need federal leadership to actually help provinces, one of which you were a senior minister in, to actually do the things that will make a difference. And there's a training program for police called First in Aid for Police, developed by NOVA. I was on their board in the U.S. and with funding from the in collaboration with the IACP. All chiefs in Canada are basically members of the IACP. And this sort of training should be given to every police officer. So I mentioned information, training. It's at the police level. Most people who are victims of crime do not go to the police, but the more serious the event, the more likely they are. And if they go, then it's unlikely that they will ever get somebody arrested or to the stage of parole. So we need to go upstream and deal with those. The stuff in the Victims of Crime Act is nice, but until we have federal funding to make this happen, working with the provinces, working with Indigenous groups, it is nothing but a bill of goods. And we knew this when it came through. Almost every U.S. state has a constitutional amendment. But California has a way of implementing this. So it becomes a reality. Marsy's law.
Thank you, Mr. Waller.
We need to be doing the same things.
Thank you, Mr. Naqvi.
Sorry.
No. Thank you, Mr. Naqvi. Now we'll over to you, Monsieur Fortin, for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Waller, good afternoon. Good afternoon to all witnesses. Thank you for being with us. Mr. Waller, my question is for you. I really like, because you say it's important to inform victims. This is a crucial issue. As you know, you're not the first witness to say so. And I would like to hear you more about that. You were talking about California. What's happening in California? But I'd also like to hear you on another question. Would it be useful, desirable, that victims of crime be part of the process automatically, that it be represented at every step of the way when there is a criminal proceeding? So those are the two questions I would like to hear you.
La situation au Québec.
I'd like to talk to you about the situation in Quebec with EVAC, which is the most generous compensation system of Canada. I'd like to talk to you about CAVAC, the supporting of victims. We're talking about civil servants who are paid to support victims. And when I was teaching at Ottawa U, I said to my students, if you are a victim of crime, you better be in Gatineau than in Ottawa. But I'll continue in French if you allow me. Look at the Rome status. It had an impact important in France. In France, there is a civil party that participates in the proceeding. There is legal aid so that the victim can participate. We should have a similar system here. Naturally, we have to have some pilot projects here and there. It could be in Montreal, combined with the criminal court and the civilian one. If we would have a similar system, there would be much more compensation for victims. It's a fiction in Canada currently. Judges think in terms of the number of years behind bars. They don't think about victims' compensation. I think we have a lot to learn from others. Canada is a member of the International Criminal Court. So victims in this tribunal have more rights and remedies than a victim in Canada. When I hear another victim like the one we've heard today, it breaks my heart. And it should break the heart of all. We have to do something concrete, measurable. Let's not let victims aside. We have to be able to measure the results. It's time to act. Thank you so much. You're talking about the Rome system. I've asked that question to other witnesses. They said we have to take into account that it's not all victims who want to be part of the proceedings for several reasons. And that belongs to them. I don't know how it works in Europe, but can a victim say, I want to be part or not of the proceeding, especially when there is plea bargaining? It's often used. I don't think it's a bad thing per se, but we have to take into account several factors, and the proceeding is not always the only outcome. But can victims say they want or not to participate, to partake in these proceedings, rather than being only a witness, a spectator, and be re-victimized? And because decisions will be taken and the victim has no say in it. It's pretty obvious that most victims of crime would like some compensation, especially for goods. So we have to find a way to make them participate in the processes. We have to provide legal aid, we have to provide a lawyer, and we have to target compensation. In France, that's how it works. Half of proceedings in France have compensation as a result. For the victims, well, sometimes they're looking for something else. Often, the offender cannot compensate the victim. But once we let the victim participate in the formal process, it will increase the chance of restorative justice. If the victim does have support, the victim needs the support. If both parties get aid and a good mediator, that's one way of getting a resolution for compensation, emotional compensation, and other.
Over and beyond restitution per se, I do think that is an important aspect of the process, I agree. But actual involvement in the trial, let's say someone is a victim of violence, there's an assault of some sort. Madame Arsenault here is the mother of someone who was victimized, who was murdered. So getting involved in the trial process, isn't this helpful? Isn't this help the victim, help them recover? It's not exactly restitution, but does it support their better health? Does it somehow reduce the level of pain?
I'll have to answer that in his subsequent round or in others, but I'll have to move on. The next round is for Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and I too want to thank the witnesses for being with us today. It's certainly nice to have Professors Waller and Wemmers back before the committee, but I want to say a special note of thanks to Ms. Arsenault. She's one of those examples that we see again and again of families who have been determined to make sure that there's a fair deal for victims of crime and to make sure that what they've gone through isn't gone through by any other family in the future. And so I salute the dedication of those like yourself, Ms. Arsenault. At the beginning, one of the things you talked about was information, and I want to go back to that point because I think you stated it very well that most victims of crime have no idea what their rights are, what the possibilities are. Can you tell us maybe a little personally of how you found out about their rights, or was it through your own perseverance, or was there any assistance?
Oh, okay. Well, thank you very much for your comments. They mean a lot to me. You know, I will be honest, I was so deep in grief for well over a year. If it wasn't for the amount of support, I mean, you have to remember there's 3 families, a lot of people. They dug through and they found it, what we needed to do. Otherwise, you know, I've helped many victims. They have no clue. They have no clue. They find out their offenders already on parole. They didn't even know. They had no clue. There needs to be some kind of agency, I would suspect government, that actually makes sure all the information gets to victims. Let the victim choose whether they want to go through these processes or not. But if it wasn't for family or friends, I would not have had a clue. That was the last thing on my mind.
So we have heard sometimes from some people saying, well, some victims don't want these services, but I think what you're saying very clearly is that without the information, they don't know what choices they have.
Well, exactly. And I mean, at that moment, sometimes you're so deep in grief, you don't even know what you want or what you need. As time goes on, you may come out of that a bit and you might now start to be mad. And you do want those resources. You do want to get involved. You know, my family, we were on them from day one because we wanted to be involved in the process. We had never been through the justice system, and it's an eye-opener.
I want to turn to Professor Waller because you talked about responsibilities for police maybe to give information to victims And I guess I'm going to be a bit of a devil's advocate here, Professor Waller. I wonder whether the police are the appropriate people to provide that information. And I think offices that support victims are probably better placed to make sure that victims get that information than the random police officers who happen to be involved in cases.
Yeah, Bill, 25% of victims of violence go to the police. About a third of victims of property crime go to the police. So the police definitely has a role. They're at the front end. I didn't say that they were to provide the service. I said they were to provide the information and referral, both things, to services that can help them. It's very hard for victims to find out about those services without going to the police. They have probably heard of sexual assault crisis centers. They may have heard of transition houses, but they probably haven't heard of the other general services that are available, and they don't know how to get in touch with them. So I strongly believe that it's a basic role that the police can play. And for those people who want to see the offender prosecuted, and property crime victims don't always want that, but if you're going to the police because you want prosecution and not just insurance, then it's really important that you are given information and that you then have somebody to support you with the police and with the prosecutor. One of the previous members of the committee raised the issue of bail and negotiation of charges, and victims need support through all those stages. And yes, parole is very important, but for the vast majority of victims, they never get to the parole stage.
And so, and maybe if I'm interpreting you correctly, that your suggestion is the police have those front-end responsibilities, but perhaps an Office of Victim Services could provide information and services later on in the process for those who go through the process further?
Yeah, I mean, if you just go back to my Edmonton example from 40 years ago, that actual victim service unit was reporting to the chief, and it was therefore in the police department. It was therefore funded, although they had a lot of volunteers. If you look at the city of Ottawa, then you have a unit within the police and you have a unit outside, and there's been lots of problems about getting them to work together. As I've already mentioned, I'm a fan of Quebec because it's taken them a long time, but they actually have professional victim services now. And I'm not sure whether it covers the whole province yet, but it's close to covering the whole province. This means that they're paying these people and they're trained, and that's what the sort of thing that we should see everywhere in Canada.
Thank you, Mr. Waller. Thank you, Mr. Garrison. That's your time for this round. Next, for 5 minutes, for Mr. Brock.
Thank you, Mr. Chair, and good afternoon, witnesses. I really appreciate your attendance today and your evidence. I'm going to talk to Ms. Arsenault, or ask questions of Ms. Arsenault initially. Ms. Arsenault, as a former justice participant, I'm very curious to hear your views on how you were treated pre-judgment in your son's case. In other words, we've heard evidence about the deficiencies in how victims are treated across this country. There are some gold standards and there are some abysmal standards, and I can probably, name a number of jurisdictions that are woefully inadequate. But I'm curious as to what your experience was and whether you have any suggestions.
Well, it's hard to be thankful for anything that I've gone through, but I guess I am thankful we did have a team of prosecutors that, I think mostly because we were on them, they did engage us. Although, I mean, you get no options of, like they say, plea deals or anything going on, or the stalling and the delaying. You have no say. You have to just go with it. But there's many that I've supported as a victim's advocate. Their prosecutors would not engage. They don't even know what's going on. They don't even know when what date is the first court appearance. So my experience, if you can say anything is good about what happened to my family, we had very good prosecutors, but that is really, to be honest, quite rare.
Your advocacy. I'm now going to move on. Did you have anything more to say?
No, I hope I answered your question.
Well, you did. You did. Thank you.
Oh, okay.
I'm going to move on now to Professor Waller. Good afternoon. I listened very carefully to the responses you gave to the question put by my colleague, Mr. Naqvi, insofar as your commentary with respect to the current version of the Canadian Victim Bill of Rights, which I think we can all agree is deficient in a number of areas. As a former participant, I recognize those deficiencies and tried to fill those deficiencies on my own. But it's not simply just an issue with respect to Crown attorneys. You'd agree it's judges, it's police officers, it's victim services, all providing a level of service that is consistent throughout this country. Do you feel that the current version of the Victim Bill of Rights can substantially improve on that delivery of service so that victims from Victoria all the way to St. John's can expect that gold standard of delivery?
I do not understand how the European Union, with 27 different governments, can agree on a series of minimum standards for victims that cover most of the things that we talked about, including what is in the Bill of Rights and more. And we can't get that sort of agreement between our provinces and territories. So the issue is, how do you actually develop those standards and get an agreement? And that's why you have to have in the federal government at a level that can actually influence what goes on, an agency that will be there to develop those standards. And if you look at England, it has legislated a code of practice which mentions all the people you've mentioned and more, and says what they should be doing. It's legislated. They started with an executive document, and then it's legislated. And the remedies in there. Maybe the remedies aren't enough, but they are remedies. We really need to wake up and get action on this. And the only way we're going to get action is that if you actually have a minister and a deputy minister who are responsible for taking the action that we need. Standards is one thing, training is another, measuring what gets measured gets done. We need to measure, we need research and development, we need reciprocal arrangements between different provinces, we need with US states. We really need to catch up and do something seriously.
Thank you, Mr. Brock.
Thank you for that, Professor.
Thank you, Mr. Waller. Next, we'll go over to Ms. Briard for 5 minutes.
Thank you, Mr. Chair. I will direct my question to Professor Wemmers in French.
We have heard Mr. Waller tell us that not much room is made for victims in our current system. We have heard Ms. Arsenault tell us that she really didn't know which way to turn after her son died, didn't know which way to turn for helper services. I'd like to know whether you feel that the Canadian Victims' Bill of Rights or even the Charter should set out victims' rights more clearly, which civil servants should inform victims of their rights, and when they should do so. Thank you for your question. The provinces administer justice, and there are differences from one province to the other. However, I feel that in the criminal process, from police services right up to parole boards, right through the end then, everyone has their role to play. It's important that all players recognize that they have a duty to victims. Not solely one police officer, one civil servant, but that just everyone feels that they need to help victims. Then it's up to the provinces to decide how they want to organize all this in a consistent fashion and in the regions, and what sort of victims assistance programs they wish to make available. In Quebec, well, they've got Quebec, for example. There are other groups, CALAC and so on, a number of groups, community groups. So this differs, or can differ, from province to province. What counts, though, is that we at least lay out that this become a requirement, as Mr. Waller has said, Professor Waller has said, that there be minimal standards across the land. Okay, that's fine, but that's not really an answer to my question. I'd like to know whether this should be specified in legislation as to who and when should be informing victims. There are good services in Quebec, fine, but if people aren't aware of them, whose responsibility is it to send them to the right places? I think we need to respect how things are organized in Canada. I think that's possible. There's one criminal code that applies throughout the land, and it's a federal code. And we might enter into procedural law texts, responsibilities for victims, how victims participate and who's responsible for doing what, the Crown Prosecutor, the police, and so on and so forth. So I think things could be added to the criminal code, and that's a recommendation that I made before the current Canadian Victims Charter, the Bill of Rights, was adopted, to ensure that there be some sort of consistency across Canada. So I think that's something we could undertake with the criminal code. In your opening comments, you mentioned that restorative justice can play an important role. We know that that approach can have very positive effects on victims as well as on offenders. Could you tell us more? What are your thoughts on how the C5 provisions will allow people to take advantage of restorative justice more broadly and cross-country? Well, what you need to keep in mind is that restorative justice can be a positive factor, but it must be based on the needs of a specific victim. Very often I see it being used as a criminal justice system intervention to sort of collapse procedures, to make it easier to get through the process and find alternate ways out. It's rather a tool that should be really handed to the victim, asking the victims, what do you want to do? What's restorative to you? Rather than a simple legal tool. You also mentioned that it would be important to strengthen communication and collaboration with the various parties involved. Could you give us some examples of how that could be done?
To do that on the next round. We're
Merci.
out of time for this.
Merci.
Thank you, Madame Briard. Next, for 2.5 minutes, Monsieur Fortin.
Merci, Monsieur.
Thank you, Mr. Chair. I will continue with you, if I may, Ms. Wemmers. You heard my questions put to Mr. Waller, and I would like to hear your opinion on that, on victims' participation at the trial level. And, of course, we often speak of some sort of restitution or financial restitution, compensation, let's say, that victims could receive. But what victims tell us is that they are not told about the various stages of the legal process, nor do they participate in them. And I'm repeating myself, but the plea bargaining matter where the Crown Prosecutor and the lawyer for the offender will be discussing, potential ways through the legal process, and the victims, who are really the first who should be involved, are not involved at all. Would it be wise to add to the criminal code some provisions to the effect that victims would be directly involved in the trial process? How to do so? Well, of course, that would have to be worked out. But, and I understand that provinces are involved in administering their own justice systems, and to my mind, that's a good thing. But is there some way to include something in the criminal code to ensure that victims are consulted not simply in matters of compensation or restitution, but throughout the entire process? Yes, of course. And that's what I suggested in 2013 when I filed a brief when the idea of a Canadian Victims' Bill of Rights was in its infancy. In the United States and the International Criminal Court, there's a sort of not really a civil party, not an equal party, but nevertheless the victim becomes a participant and thus has rights to information, rights to legal representation, and to recourse as well, should their rights not be respected in the process. That's what takes place in the United States, at least in a number of U.S. states. And we could use things that are already in the criminal code, the mandamus, for example. That's a legal term. I could send you the report, the brief, basically, that I brought in back then, what we were looking at back then. I think we already have that brief, but yes, otherwise I would be very happy to read it. Thank you. Thank you, Chair. I think I'm out of time.
We have Mr. Garrison for 2.5 minutes.
Thank you very much, Mr. Chair. I want to return to Professor Wemmers. One of the interesting things to me in most of the discussions about victims' rights is there's very little explicit attention paid to gender. And I wonder if Professor Wemmers would like to comment on the factor of gender as it applies to victims' rights.
Excellent point, and I think that that's something that we're seeing come up more and more. Gender-based violence, domestic violence, etc. It's not just gender as well. It's also, LGBT, two-spirited plus, etc. And I think there's been tremendous progress in terms of intersectionality, understanding the different vulnerabilities as well, and how they can add up. If someone, you're not only female, you're also gay, you're also black, etc., and how that makes someone all the more vulnerable. And I think that is something that we're seeing. Now the question is, how do we adapt our criminal justice response to that? And that's the challenge. But already recognizing it, I think, is an important first step. And that we're already talking about it. I think that is, it's a start. So yeah, we have to start recognizing how gender influences some of the decisions that we make and some of the vulnerabilities of victims as well.
I know we're just about out of time here today, but you talked about the minimum standards several times in your opening and in the discussion. Do you believe that this question of minimum standards for victim services is well enough developed that, for instance, something like the Justice Committee could make recommendations to the government very easily on what the standards should be in every province and in the federal system on victims' rights? Do you think that that's sufficiently developed that we could do that?
Yes, I do. Yes, I do. And I think that if we look at organizations like Victim Support Europe, for example, we have wonderful examples that we can follow. I can tell you that the Conseil d'Europe right now as well is working on new recommendations for victims, bringing up to date those that came out back in the 80s. So as Professor Waller said, it's time for us to catch up. There are wonderful examples out there that we can learn from. And yes, I think Canada has an obligation internationally to do so, given our responsibility in the UN.
Great. I think I'll leave it there, Mr. Chair. Thank you very much to the witnesses once again.
Thank you, Mr. Garrison. For our last round, we have Mr. Richards for 5 minutes. Over to you.
Sure. Thanks, Mr. Chair. I'll start with you, Ms. Arsenault. First of all, let me just say, and I know it's been said, but it can't be said enough, thank you, for your courage. Frankly, in being willing to step forward and take what's obviously a tragic and terrible situation that you and your family have gone through, and try to do something to help others. Because what you're doing today, and I'm sure many other days, is really trying to make this process a little easier on other people who unfortunately are put in the circumstances that you and your family were put in. I know it won't do anything for you, but it will hopefully help many other people not have to experience the same kind of frustration and pain that you had to experience going through the so-called justice system in our country. So thank you for stepping forward and doing that, first of all. Secondly, I think, a lot of the things that you had to say and some of the recommendations that you've made really speak to the problem we have with our so-called justice system in this country. I mean, you spoke to it. I think you even said it yourself. It feels like criminals have more rights than victims. I don't think it just feels that way. I think that's the way it is. And certainly, that's borne out in many of the examples you gave to us. One thing that you mentioned in your opening statement was Section 101 in the Principles Guiding Parole Boards. You've mentioned that briefly, and you mentioned the idea of adding the need to add in there that parole boards should consider the impact on the offender's victim of conditional release. And I think that makes a lot of sense, that should happen. And I wanted to just kind of hear from you why you think that is important, and is there other things that can be done in the same vein to make sure that the offender doesn't have their rights put ahead of those of the victim over and over and over again, that the victim's rights actually do get considered, and not only considered, but made a priority, because they should be.
Yes, well, I mean, there's no doubt about it. Offenders have many, many, many rights. It's you can't even compare to the rights of a victim. From what I can tell, we have one right, and that is to write a statement, and that's about it. Section 101, which does outline the principles that guide the parole boards to consider the impact of conditional releases on the offender's victims. I really do believe that could be amended for them to look at their decisions a little differently, to see what kind of effect that would have on the victims when they do these incredibly early releases. A lot of times the offenders do not demonstrate or show any kind of remorse. And, that needs to be looked at seriously. They need to take consideration of all the available information to them, including the reasons and recommendations from the victims, why that would be harmful to them with these early releases.
And are there any other recommendations that you can think of that you would make along that same line that would, ensure that victims and their circumstances and their rights and their feelings and what they're going to experience as a result of decisions that are being made by bodies like a parole board, that those are put as a priority, as a much higher priority in our justice system? Is there any other recommendations along that same line that you can think of?
Well, I mean, I would recommend that the victims are, with their impact statement, they are allowed to say exactly what they want to say. It shouldn't be scrutinized and looked over, hacked and whacked, redacted. You're the victim. If you need to say something, you should be allowed to say it. I do believe that all victims should have the choice of whether they want to face their offender or not. And the parole board should really start limiting the number of people that an offender is allowed to have support them, because it's about the crime and the rehabilitation. It's not a popularity contest.
Thank you.
To me, okay.
Yep, sorry, Ms. Arsenault. Last round
to
Ms. Dillon for 5 minutes.
wasn't expecting your time, but thank you. How much time do I have? I have 5 minutes. Okay. So let me start with Professor Wimmer, and I think this question was asked earlier about, and I think Ms. Arsenault has spoken about this, that no two victims are alike. They come from different backgrounds. I think the question was asked around victims who are women, what kind of different strategies needs to be deployed there. I also want to ask a similar question around those victims who are new to Canada, who are immigrants and may not know the system well enough. What kind of strategies need to be deployed in that regards?
It's excellent question. It's very broad as well. You have to bear in mind, of course, that I hear an echo. Is that sound okay? Yeah. Okay. That it's the individual and their situation, their victimization. All of this will determine exactly what their needs are. There's one thing, the impact of the crime, but also their resources will determine to some extent the needs of the victim. And of those who are new migrants, maybe even refugees new to the country, their situation of vulnerability is often more precarious. There are, in terms of financial resources, not having the informal support network, family here in Canada to provide them with the psychosocial or the emotional support that others may have. And also legally, there might be complications as well, as you might find that, there might be consequences for their status as a landed immigrant, as a refugee. In particular, if I'm thinking of victims of domestic violence, for example, where the offender, like them, is a new immigrant, not a Canadian citizen, and that this may have consequences for the status of the person, their ability to remain in Canada, and if it's a family, all the consequences for the family. So it becomes very, very complicated, if I can put it that way, and something that requires us to bear in mind what are the needs of the victim, and when are we helping the victim, and when are we actually adding to their suffering indirectly, but to bear that in mind. The complexities of the needs of new immigrants, and in particular, say, refugees, people with a precarious status in Canada.
Professor Waller, I'm going to come back to you, and I may, with all respect and affection for you, going to push back you a little bit on your suggestion, your recommendation on creating what you call the Crime Prevention and Victims Canada, a new department, as you are suggesting. And my question is this to you. Do you think, in your view, more bureaucracy is the answer to protect and provide better rights for victims?
I think more funding. I think if you look at the Victims of Crime Act in the United States, it has definitely changed what is going on. It's not a huge bureaucracy. It's part of the U.S. Department of Justice. I didn't actually recommend a new department. I recommended at the deputy minister level. I think it's the only way to get standards from coast to coast, to get services that meet those standards, to get information out, to start making laws relating to restitution actually work, to experimenting and developing a way for the victim to actually participate. And there hasn't been much discussion today, but I strongly want to see what you actually started in Ontario. We need to do a lot more to stop people being victims of crime in the first place. We know what will reduce victimization, so the street violence, by 50% or more. We know what to do about a lot of sexual violence. We don't have all the solutions, but we have a lot of solutions, and that requires money. I'm proposing funding of the order of 10%, of which roughly half would go to victims, half to prevention. This is not creating a huge bureaucracy. This is promoting a way to make a lot of things happen in collaboration with the territories, provinces, and Indigenous people. And I want to see results. I want to see stuff measured so that we actually focus on this stuff and we don't get more bills of goods. And you can see from the US, you've got all these constitutional things, but once you actually put money into it and you do it seriously, you look at England where there are ministers responsible for victims, you see action. You see this in Australia and in New Zealand.
So thank you.
Unfortunately, Mr. Naqvi, we're out of time. Thank you, Mr. Naqvi. I want to thank all the witnesses. But before I adjourn, I just want to inform you of the progress we made on booking our witnesses. We went through the list, including those requested to appear. We still have 6 invitations left without a definitive answer. So we will be meeting on Monday from 11 to 1 p.m. And we have, I believe, the confirmed witnesses are Madame Guadreau from the Association of Quebecois Plateau Victims, and Women's Legal Education Action Fund, Kat Owens, and the Canadian Centre for Child Protection, Monique Saint Germain. And for the second hour so far, we have Madame Brenda Davis, and we have Madame Melanie Sereno of Land Centre d'Aide aux Victimes. For Thursday, we only have witnesses for the first hour so far. The witnesses confirmed are Madame Morel Andrews and Madame Diane Ilesic. So we don't have witnesses for the second hour confirmed. So if you have any witness you propose, just maybe give them a call, nudge them, so we can have them finish it. Otherwise, thank you. And for those that we won't see, sorry, Mr. Dansingari.
Is it possible to get a summary witness testimony by Thursday? So
yes, we can provide that to you. Yep, absolutely. Thank you. Otherwise, yeah, we'll try to get it to you before that. We'll get it to you for Monday. We'll get it to you for Monday. Yeah, before the Thursday day. Sure. Thank you, and we'll adjourn and see you Monday.
We have pending for Thursday.
Okay.
So I guess